Hello, everyone. Thank you for joining and welcome to the session on India's insolvency law, updates and developments. This is Amit Khandelwal. I'm an analyst at SC Loy's Singapore office and will be the moderator for today's session. Over the past few months, there have been several regulatory and case law updates in India, which have a direct impact on credit investors. Through this session, we are looking to distill the various changes and highlight what this means for credit investors. Joining us today is Ashwin Bishnoi, who is a partner with Khaitan and Company. He specializes in corporate restructurings and private credit, having cut his teeth at Skadden Arps in New York and London. In the post-IBC era, he has advised several investors on various complex matters and is IFLR's R&I lawyer for 2021. Let me begin by giving you an update on the session format. The session is designed to be an interactive session. While we will start off with a few slides covering topics for today's discussion, we will be taking questions throughout the session. You may send us your questions live by typing them in the questions box, and we will pick up the questions during the discussion. For any overflow questions, we will pick them up towards the end of the session. In case we are unable to get to your question today, we will get back to you over email after the session. Also, please note that the deck will be sent via email after the session. So hope you can all focus on the session and don't need to spend time taking screenshots. Ashwin, thank you very much for joining us today. Would you like to begin by sharing your thoughts on how the IBC process has delivered so far, and also what has been the impact of COVID?
Yes, sure. Firstly, Amit, thanks for having me. And morning, good afternoon, good evening to everybody who's joining us. It's my pleasure to be here. And in today's session, I'll cover some of the on-ground realities in India. So I often get asked the question, how is the bankruptcy tribunal doing? What's the time taken in these cases? What is the IRRs? What are the recoveries? So I'll touch upon some of those. And I'll also touch upon some of the legal and regulatory updates which impact particularly private credit investors. So to keep the process very efficient and to conserve on bandwidth, I'll go off camera for now, and we can come back on camera towards the end when we have questions. So can we go to the next slide, please? Thank you. So the IBC came into force in 2016 and clearly has had a dramatic impact on the credit landscape in India. And the bankruptcy court, which is the NCLT in India, plays a very critical role in this process. In fact, it directly impacts IRRs, given that that's a function of time and recovery. And if you look at pre-IBC, the recoveries took on average 4.5 years. This has come down to 1.5 years post the IBC. And the statistics on this slide, unless it says so specifically otherwise, are since the inception of the IBC. But there is no denying that in the last 8 months, this average time has increased from somewhere between 680 to 727 days, depending on which quarter you're looking at. And even the average time to open insolvency proceedings has increased to about 4 to 6 months. Now, this has principally been, in my opinion, because of COVID, when hearings went online and judges were more sympathetic to granting adjournments. Now, there have also been vacancies in the NCLT, all of which has resulted in the figure that you see, that the number of pending cases has mounted to nearly 13,000. And by cases here, we mean every piece of litigation, not just the number of companies which are in insolvency. But if you ask me, the situation in recent times is clearly and decisively changing. The central government took note of these recent delays in a joint parliamentary report and increased the budget of the NCLTs by nearly 25%, it increased the budget for the NCLATs by nearly 50%. The Indian Supreme Court, which is the apex court in India, as recently as September of 2021, re-emphasized to the NCLTs that time is of the essence. And the several vacancies that I have pointed out, several of them have been filled. The government appointed 18 more judges to the NCLT, though if you ask me personally, a lot more can be done in that space. Justice Sudhakar has been appointed as the president for the NCLT on a long-term basis for 5 years. Justice Bhan has been appointed as the NCLAT, which is the appellate tribunal, chairperson for 4 years. And in the Supreme Court, Justice Chandrachud is highly regarded and a suitable heir to Justice Nariman's claim to being one of the important judges to shepherd the IBC through the Supreme Court. And Justice Chandrachud's tenure is till November 2024. So there's a lot of permanence and long-term longevity in the bankruptcy court system now. A new IBBI chairperson, which is the insolvency regulator in India, is expected to be appointed in February. So all of this, to my mind, augurs well to tackle the pending cases coming out of COVID-19. Can we go to the next slide, please? So as the IBC celebrates 5 years, we get a clear picture of its successes and challenges, or at least a clearer picture. So since inception, 4,541 insolvencies have been opened, and 63% of them have closed, with 71% taking more than 180 days. 14% of the closed insolvencies resulted in out-of-court settlements, and 16% in a successful resolution plan. Unfortunately, half of the closed insolvencies resulted in liquidation. And if you ask me, I think a high number of liquidations is because of the large number of zombie corporations that existed pre-IBC because of the failure of the earlier insolvency laws. And this is alluded to in a government report as well, that at least 73% of the companies that went into liquidation were defunct companies. The average financial creditor recovery since IBC's inception has been 36%, while it was 20 to 25% under the earlier laws. But of course, under the earlier laws, time taken to resolve was much higher and insolvency costs were also much higher. And the total recoveries under the IBC till June 2021 has been a quite incredible $32 billion. In 2020, when more viable companies were resolved and resolved faster, the average recovery for financial creditors was actually 71%. Now, I think the COVID-19 caused delays in the last 18 months will be a drag on these numbers. But that is no different for any other jurisdiction, I would suspect. And I think the IBC remains the preferred forum for credit enforcement and restructuring in India.
So, Ashwin, one of the most significant changes that we have witnessed is a change in borrower behavior today. Today, the fear of losing one's company is very real, and borrowers are much more constructive in their approach towards resolving issues versus, let us say, in the pre-IBC era. In fact, we are involved in situations where the borrower actually calls us a day before the payment due date. He shares the SWIFT messages and confirms that the payment has been made. So this never really used to happen before the IBC. And to me, this is a big achievement in itself. And it has happened primarily because NCLTs and Supreme Court have been fairly creditor focused. But like you said, the IBC has been operating for just about 5 years. So for all practical purposes, it is still actually quite young and obviously still evolving. In fact, even if we look at the last 18 months, there have been several developments which impact all of us. Would you like to highlight some of the key case laws from the last 18 months and flag how they impact us?
Yeah, that absolutely, Amit. And before I go there, I think the point that you made is absolutely correct. And that's the reason why we are seeing a lot of pre-IBC one-time settlements as well. The fear of losing one's company is quite real. We're also seeing certain instances where the sponsor in India is quite vigorously agitating his or her claims in the bankruptcy courts because he knows that once the insolvency is opened, he is going to lose control of his company. So the threat of loss is quite real. And I think it's been one of the cornerstones of the success of the IBC. So I'm very much in agreement with you there. If you can move to the next slide, you're very right. There have been quite many updates. And for simplicity's sake, what I have done, Nitesh, can we go to the next slide, please? Yeah, thank you. So for simplicity's sake, I have categorized them into 3 buckets here. In bucket 1, I discuss decisions that impact inter-creditor relations. In bucket 2, those that impact guarantees and pledges. And in the 3rd bucket, those that impact financial debt and their categorization. So these are covered in this slide. And in the next slide, I'll deal with some changes that have impacted resolution plans, making them easier and hopefully recoveries faster. So let's start with the first bucket. Indian courts have repeatedly held that courts should not interfere in the commercial wisdom of the COC or the Committee of Creditors in arriving at a resolution plan. In fact, this has been one of the cornerstones of the IBC's attractiveness, Amit, as you will recognize. But in a rather odd decision, this principle was, to my mind, taken beyond its breaking point. The NCLAT, which as I mentioned earlier is the Bankruptcy Appellate Court, held that the Committee of Creditors, with the consent of 66% of its members by value, can vote to disregard senior-junior priority in a collateral. And the oddness of this case is best explained by the fact that in this case, the senior lender, who was a minority in the debt stack, mistakenly voted in favor of a resolution plan which disregarded its senior ranking. And in yet another decision on similar lines, the NCLAT held that the interstate seniority of secured creditors over the same collateral, so one being senior and another being junior, will be disregarded in liquidation where the senior creditor relinquished its security in favor of the liquidator, for the liquidator to then go and enforce and sell the collateral together with all the other assets of the liquidation estate, as opposed to that creditor enforcing on the collateral itself. Now, the logic being that if the secured creditor were enforcing its security interest on its own outside the IBC, it would continue to have the benefit of the senior ranking. But by relinquishing its security interest to the liquidator and gaining access to sale proceeds of all the other assets of the liquidation estate, the secured creditor somehow submitted itself to the liquidation waterfall in the IBC. And this waterfall does not recognize interstate priorities between senior and junior charge holders. Now, this decision has been appealed to the Supreme Court and has been stayed by the Supreme Court. It's, I think, comfort for you, Amit, and for other private credit players out there that this only impacts you if you elect to relinquish charge in favor of the liquidator. It is not something that happens automatically, and it does not happen if you as a secured creditor were to enforce the collateral on your own outside the IBC. But such individual collateral enforcement can be time consuming and costly in India, which is the reason why the IBC has been favored. Unless you as a private credit institution have access to India's faster collateral enforcement law, which is popularly called SARFAESI. And SARFAESI is available to private credit investors only if the bonds are listed. And that is a token listing, as many of you will know. And I would highly recommend it for the SARFAESI benefits it provides.
So Ashwin, you talked about this thing wherein you said that senior junior structure has kind of been disregarded. Obviously, this is not ideal, and especially because most trades that people like us do with NBFCs is where you take over a senior loan, and that involves the senior junior structure. So, what do you think the creditors need to do in order to, quote unquote, solve for it and get comfortable with their security package slash structure in this scenario? And also, maybe you can talk about, like, do you really think that this ruling will stay, or do you expect it to actually get overturned when it goes to Supreme Court?
You're quite right, Amit, that this is not an ideal judgment, to put it mildly, and it impacts private credit more, since quite often you will be providing that last mile financing or the last rescue capital, which will correct the debt stack, but you will not be a majority of that debt stack. But we have been able to get investors comfortable around this risk. Firstly, if you remember, the NCLAT decision was couched in respecting the commercial wisdom of the committee of creditors. So make sure that your vote in the debt stack does not go below 33.1%, so that no such resolution plan disregarding senior junior can be approved by the COC. So this gives you a blocking right. Secondly, enter into a voting agreement such that the voting rights of the junior debt are assigned to you, and so that you in effect control 66% of the voting rights in the debt stack. So this should also ensure that you can pass a resolution plan that respects the senior junior priority. Now, however, the second proposition, though tenable in my opinion, is as yet untested. And as to your second question, I'm quite hopeful that this NCLAT decision, if it were to go to the Supreme Court, will be reversed, since there is already an earlier decision of the Supreme Court on this point under the earlier insolvency law in India, which actually upheld senior junior priority. In fact, this question even went to the Insolvency Law Committee, and the Insolvency Law Committee brushed it aside to say that, look, the law is abundantly clear on this point and it's not required to be clarified. And lo and behold, we have this judgment. So I'm quite hopeful that the Supreme Court will rule in favor of respecting senior junior.
Right. Okay. That is comforting.
Okay. I think if I can move to the second bullet point in the first bucket here.
Sure.
In residential real estate insolvencies, home buyers, as we know, have been for some time now elevated as financial creditors. This is a quirk of Indian law. However, recent changes require that 100 home buyers or 10% of the home buyers in a project, the lower of, must come together to initiate insolvency. And I think this has made it more difficult for home buyers to initiate insolvency, and has reduced the number of residential real estate insolvencies. But since we're in the bucket of inter-creditor concerns, home buyers are financial creditors. And as you can imagine, their interests are quite different from those of credit institutions. And they do have voting rights in the committee of creditors. So it's important, I think, for you to assess how much of the committee of creditors decision making will be controlled by home buyers before you invest in any such debt stack. Moving on to treatment of dissenting creditors as another inter-creditor impact item. The IBC requires that dissenting financial creditors be paid their liquidation value prior to any payment to consenting financial creditors. And this has been known for a while. But one critical element was clarified by the Supreme Court in the JP case in the last 18 months. And here the plan provided for land to be allotted to dissenting creditors. And the Supreme Court ruled that when a financial creditor dissents, what it really wants is that it wants out of that credit and it wants cash. So the Supreme Court ruled that dissenting creditors should receive their liquidation value as cash and not as land. And I would hazard a guess that this would apply equally to any other form of non-cash consideration. So, for example, securities or bonds or equity. And that's something to be taken note of as you sit in various committees of creditors. In yet another decision that impacts interstate lender rights, the NCLAT held that where there are multiple lenders who share a collateral security, unless secured creditors have 60% of the debt, they cannot stop the liquidator from selling their collateral as part of the liquidation estate. Now, this is clearly not the law. And in fact, in liquidation, it is each creditor for itself. And the law presently requires all 100% of those creditors who share a collateral to relinquish that to the liquidator, for the liquidator to then sell that as part of the liquidator's process, or each such creditor is then free to exercise its own enforcement rights. This decision of the NCLAT has been stayed by the Supreme Court. But the tricky question of how a deadlock in such a situation will be resolved, where let's say the senior creditor wants to enforce individually and the junior creditor wants to enforce through the liquidator, is something that remains to be resolved. I'm now going to move to the second bucket, which is about guarantees and securities. And this presentation has a 18-month look back period, and in that 18-month period, one of the widely popular judgments was the JP Supreme Court judgment. And the Supreme Court in that case held that a lender who has the benefit of a third-party security is not a financial creditor of that person that's provided the third-party security. And as we all know, a financial creditor in India has a much higher standing in terms of voting in the debt stack, in terms of recoveries, than a non-financial creditor. So being a financial creditor is important. And if a lender who is a beneficiary of a third-party security is not going to stand as a financial creditor, that's a problem. And the Supreme Court held this despite the fact that the mortgage document contained a clause imposing an obligation on the third party to pay if the principal borrower defaulted. Now, if you ask me, this is an odd outcome, but again, I think the market has taken this decision in its stride, and now it's fairly on market to insist on a separate guarantee deed from every third party security provider, since a guarantee is clearly recognized as financial debt, and you will be a financial creditor under the IBC, with all rights to initiate insolvency and all rights to vote your debt in the committee of creditors of that insolvency.
Right. So, yeah, sorry, go ahead.
No, go ahead, Amit.
Yeah. So, look, the question that I had is, typically we as investors, and for that matter, probably everyone on the call, we would always like to have like multiple strings to our bow, right? So basically, everyone will like to secure the debt with multiple guarantors, mortgages, pledges, basically whatever security you can negotiate and get, you'll want to ideally have everything with you. Now, given these recent developments, what's the practical enforcement advice would you like to give to your clients in such scenarios?
Yes, Amit. In fact, let me come to this question after I've touched upon another legal development, and I think it will shed light on how you should think about enforcement where you have multiple collateral. So, you see, multiple Supreme Court decisions have held that insolvency can be initiated against the principal debtor as well as the guarantor. I think that is now fairly settled. However, there's a recent NCLAT decision that held that if you have insolvency opened against one guarantor, then insolvency cannot be opened against another guarantor for the same debt. Now, if you ask me, this is clearly flawed, since it is quite well recognized in Indian law that guarantees are distinct and separate obligations. And therefore, it came as no surprise that the Supreme Court stayed this case. But let's apply this case to the question, Amit, that you've asked. Now, while this decision has been stayed by the Supreme Court has not as yet given its decision on this matter. And so if you are agitating this issue before a bankruptcy court in India, at the very least, it will be cause for some delay. Now, let's say you have a debt stack where you have two corporate guarantees, and you were to file insolvency applications against all these guarantors at the same time, and they were to go before different benches who are not coordinated. So you run the risk that insolvency is opened against the lesser valuable guarantor rather than one which is more valuable. So as an enforcement strategy, what we are seeing is that you wait till the more valuable guarantor is admitted into insolvency first, and then file for insolvency of the second guarantor. So that if in the hearings for the insolvency opening of the second guarantor, the Supreme Court decision and this NCLAT decision were to come up and cause a delay, which hopefully it shouldn't because the Supreme Court has stayed this decision. If that were to even happen, then the guarantor with more valuable assets to you has already been admitted into insolvency.
Okay, so at least there is something that can be structured around it.
Yes. Moving on to the third bucket, and I think this is important as well. There are several decisions that have interpreted what financial debt means, and as I alluded, being a financial creditor is important under Indian insolvency law. So as recently as 2021, Supreme Court decisions have held that zero coupon bonds and even PIK loans are financial debt. And I think these are important decisions, though obvious if you ask me. And the fact that these instruments don't carry a coupon does not take away from their character of being financial debt. So I think with that, if I were to summarize this slide before I move on to the next slide, I think no doubt there have been some very, very important decisions that have strengthened the foundations of the IBC. But there have also been some unpredictable decisions, especially at the lower judiciary level. And fortunately, I find that especially in this 18-month look-back period, these have been quickly stayed by the Supreme Court, even without waiting for detailed arguments. And I would think these are emerging market risks that you would price into your India IRR expectations and assumptions. And I suspect that several of these decisions will go in favor of creditors before the Supreme Court. Otherwise, it's not just the private credit institutions that would be up in arms.
Correct. Actually, these things impact like everyone, whether you're in distressed debt or whether you call it special situations, or even if you're doing private credit. As long as you are a creditor and as long as you're looking to enforce security or resolve a situation, I think these points like impact all of us.
Absolutely. I think, Mitesh, with that, we can move to the next slide, please. Thank you. So in this slide, I will touch upon some developments that impact resolution plans and recoveries. Thankfully, the Supreme Court continues to reiterate that the NCLTs have limited power and should not interfere in the commercial wisdom of the COC. In two landmark decisions, the Supreme Court has also ruled that a counterparty cannot terminate a contract. In fact, one of these decisions came out as recently as yesterday, where the Supreme Court held that you cannot terminate a contract with a debtor as a counterparty solely because of the insolvency of that debtor, where the contract is essential for the revival of the debtor in insolvency. In more developed jurisdictions, these are called ipso facto clauses. And as you can imagine, this is a big fillip to the chances of revival, and it has applications in all kinds of contracts. Think PPAs, for example. In fact, the Gujarat Urja Nigam decision of the Supreme Court was in the context of a power purchase agreement. The third bullet point here is Supreme Court has also clearly held that white knight resolution applicants cannot be saddled with hidden and surprise liabilities, and it must get the benefit of a clean slate. As an advisor to several of these resolution applicants, we have spent hours and broken our head as to how do we solve for some of these hidden liabilities. And this Supreme Court judgment has come as much needed relief for such bidders. Also, and more significantly, after Bhushan Power and Steel, Section 32A was added to the IBC, which makes clear that money laundering and proceeds of crime consequences of the previous owners do not travel with the debtor in the hands of the new resolution applicant. So this is a significant positive for resolution applicants, and for COCs as well. It means that you can attract more bidders and run a more competitive bid process. In another recent change, the IBC was recently amended to allow the committee of creditors to vote on multiple plans simultaneously. The argument being the more plans that make the final fray, the higher chances of better valuation. Though Amit, personally speaking, I think this level of prescription should not have been required. I think market forces should have ordinarily come to this conclusion in any event. But it is a net positive change. And in keeping with that spirit of improving competitive dynamics, in our look back period for this session, the IBC was also amended to allow the promoter to offer a settlement till as late as the resolution plan is approved by the committee of creditors. While in some situations I think this may drive competition, I think in most situations the committee of creditors struggles to hand back the company to the promoter. Case in point being DHFL, and there are several others. So if you ask me, this remains a paper tiger. The Supreme Court also recently in EBICS ruled that a resolution plan is not like any normal contract. It is a higher form of statutory contract. There are severe consequences for its breach. And importantly, it held that the resolution plan cannot allow the bidder to withdraw or modify the plan, even if it is specifically contained in the resolution plan agreed between the bidder and the committee of creditors. I think this decision forgets that oftentimes regulatory consents are needed, and to require a bidder to perform on the plan absent such consents, to my mind, is unfair, potentially even illegal. But all the same, it makes sure that resolution plans carry a much higher degree of certainty, which I think is a very positive development for members in the committee of creditors. Though if you ask me, given the time that NCLTs are taking in approving resolution plans, some leeway should have been allowed for MAC clauses or long stop clauses, where if certain conditions are not met by a certain time, then the bidder can walk away from the deal. I think a fair bidder asks. And straight jacketing a resolution plan so tight may dissuade investors who are less familiar with Indian vagaries from participating in the bidding process. But still, I think this is a net positive development. In other developments, while the IBC has not yet fostered a regime for cross-border insolvency or group insolvency, courts through creative means have achieved this in the Jet Airways and Videocon cases, as you may have followed. Now, while I'm not a huge fan of the NCLTs overstepping their remit, to me it does show that Indian courts are not averse to adopting best international practices. And so when the IBC does morph and does adopt cross-border and group insolvency rules, I think this augurs well for that stage. And lastly, and certainly not least, the IBC regulations were recently amended to require the committee of creditors to act in accordance with a code of conduct that is to be prescribed, as yet unprescribed. And a draft code of that has been released for public comments. So if I were to summarize this slide, I think there are several amendments, both by the judiciary and by the regulator, which are designed to make the resolution process faster, transparent, and more certain. Some of these are, if you ask me, too prescriptive, but they are still in the positive direction, and I see of them as positive changes.
Right. Actually, several points on this slide are really very interesting. So just touching on a few of them. So point number 2, when you talk about like no termination of contracts, so let us say if there is a power purchase agreement between a power generation company and buyer, and then the power generation company goes into insolvency. So does this mean that the power purchasing company cannot terminate the PPA, even if the PPA explicitly says that in the event of bankruptcy of any counterparty, the PPA falls away?
Yes, that's right. So there are two conditions that you will need to meet. One is that the termination is on grounds of insolvency, and the second one is that the PPA is an essential contract without which it is not possible to revive the company in insolvency. And so let's spend a moment on each. I mean, for one, the insolvency law remit is very clear and crystallized. So it can only stop a termination if it is on grounds of insolvency. So if, for example, there are delays in supply of power, if it doesn't meet the standards specified in the contract, or if there are other grounds on which termination can be, or the contract can be terminated, then that still stands. But the contract cannot be terminated on grounds of insolvency. That is one. And secondly, the contract must be one which is essential to the continuation of that company as a going concern. Because again, the remit of insolvency law is credit and insolvency. So you cannot be affecting the rights of other counterparties under contracts for contracts which are not essential to the company carrying on as a going concern.
Right.
Amit, I hope that answers your question.
It does, yes. So talking about the third bullet with regards to whitewashing of past liabilities. So, this was a big challenge for us when we were one of the resolution applicants in a particular situation, because there were a lot of names and accounts where there were several potential liabilities that could have come up because of past actions of the previous management. So does this mean that by virtue of this development, the bidder actually will not be held liable for the actions of previous management, and that will not create new liabilities for the buyer? Do you think that issue is now completely resolved?
The answer, Amit, is yes. With the introduction of Section 32A, to my mind, this issue is resolved. There are some exceptions in 32A which you should know about, but I don't think they will ever concern you. And in simple terms, the benefit of 32A is not available to a bidder if that bidder is colluded with the erstwhile promoter, which I think will anyway disqualify you from bidding in the first process. And I think that's not a standard that will apply to any one of you. So yes, I think with 32A, that decision is resolved. And I think it's an important one. See, even under the earlier insolvency regime, one of the largest earlier scams was the Satyam scam. And in Satyam scam, one of the successful bidder finally took over Satyam. And for quite many years, the successful bidder was saddled with the litigation emanating from earlier money laundering and criminal violations. Until finally, maybe I think 2 years later, a court said that, look, the controlling mind at that point in time of the Satyam scam is very different from the person who finally rescued it and came in as a white knight. But it still took a good 2, 3 years for that decision to come about. And it was left to a court to say that, and it did not have very firm grounding in a provision of law. So 32A is a very firm grounding for that position under the IBC.
Got it. Okay. Then, you talked about the code of conduct for the COC members. Now, as creditors, on several or most occasions, we are part of the COC. So what does this code of conduct mean for people like us, and what kind of bearing does it have? And how do you see this code of conduct actually impacting members of the COC on a practical basis?
So, Amit, the code of conduct attempts to regulate committee of creditors, and it puts a duty of care on the committee of creditors to be fair to all stakeholders and to act in a transparent manner. In fact, in the UK too, there is similar guidance on how members in the credit committee should behave, perform. And there is a draft code of conduct out there for public comments. And it requires the committee of creditors to, for example, act with speed, have properly authorized personnel attending meetings of the COC so that decisions move fast, to disclose any conflicts, to maintain the integrity and timelines, all of which, if you ask me, are net positives. But there are a couple of things which I think one needs to watch out for. The introductory text of this draft code of conduct does talk about the fact that there is a duty on the committee of creditors to act fairly and in the interest of all stakeholders. And I think the committee of creditors is a very nascent body. It's coming out of an NPL crisis. Committee of creditors are predestined to sort of act in their own interest, of course, with an eye to balancing the interest of all stakeholders. But I want to just keep an eye on whether imposing a duty on the committee of creditors does not open a new avenue for litigation. And it's not something that the regulator is blinded to. In fact, I think that's probably the reason why it has taken so long for such a code of conduct to come about. And in that draft code of conduct and that discussion paper, it's quite interesting, Amit. It talks about examples of conduct by the committee of creditors, which has resulted in this concept of the draft code coming about. And those examples are fairly stark, none of which I think would apply to any reasonable-minded committee of credit member. So I would not be too overtly worried by the casting of this duty, but it is certainly something that I will be keeping an eye on.
Got it. So it probably makes like the conduct of all members of the committee more in line with how you would expect in any other international insolvency situation, right?
That's right, and it's just an extension of how committee of creditors have been behaving in any event. So you do need to provide for payment of workmen, you do need to provide for payment of employees, you do need to provide for trade creditors where they have liquidation value. So none of that is being upset by the introduction of this draft code of conduct. It is just to make sure that the speed that is required to implement resolution plans, any disclosures of interest, they need to be honored. There is, though, one interesting bullet point that is there in the draft code of conduct, and I will be intrigued to see if that were to survive the final form. It says that DIP finance or interim finance should be provided for a debtor in need. Now, no law in India can force a member of the committee of creditors to provide DIP finance. And no law in India can, India does not have the US DIP finance priming concept. So there is no law in India under which a member of the committee of creditor can be forced or crammed down to take any, for the debtor to avail of interim finance. So for that to slip in by way of a draft code of conduct, I think is a stretch too far. So I don't think that the addition of that bullet point in the sort of aspirational code of conduct for committee of creditor members that they should be willing to provide DIP finance will result in an obligation or priming. But it is interesting what that bullet point says, and again, something that you should keep an eye on.
Got it. Okay, thank you.
And keeping an eye on is a perfect segue to our next slide. So Nitesh, if you can go to the next one, please. So here are some other things that's in and around the IBC, which you should keep an eye on. And given that we are running out of time and we want to keep some time for Q&A, I won't spend too much time on this slide. But as you all know, there is a pre-pack regime for MSMEs in Indian. And the question that's on everybody's mind is whether this is a test case for larger corporates, and it's something that we all should keep an eye on. Also, more and more personal insolvency cases are being filed before the bankruptcy courts, and that's also something that will find its own course. We'll see some of the hurdles that the corporate insolvency process went through being revisited in the case of personal insolvency, and that's also something that's to be kept an eye on. There's a recent RBI report that suggests that ARC should be permitted to participate as bidders, given that a lot of private credit debt is through the aggregation model. I think this is a no-brainer to my mind. ARC should be permitted to participate as resolution applicants, and so I'm hopeful that this change will come about. There was also talk and something in the press that DISCOMs, which are state-owned power distribution companies, do not have any exemption, and they too can be taken to insolvency. So given what's happening with, say, road projects and highways, and a lot of resolution plans and claims trading happening on the back of NHAI payables, I wonder if a similar play will develop in the context of DISCOMs. There have been changes where the role of the stakeholders committee has been increased in liquidation, so creditors have more of a say. If you remember the first slide, a good number of cases are currently in liquidation, and so they may be, I think if any one of your situations are unfortunately in liquidation, there is an increased role for the stakeholders committee. Also, interestingly, recently the law was amended to allow the liquidator to assign non-readily realizable assets, including contingent litigations, for example, avoidance claims. And given the funding and time that those litigations will take, given that a resolution plan needs to have finality, very often these are just left by the wayside. And that's just money left on the table sometimes, though it requires gumption and litigation to go after that money on the table. I wonder whether that's the beginning of litigation funding in the context of avoidance transactions. So these are just things that we should keep an eye on. And I think with that, Amit, happy to take any questions.
Right. So we would like to request all participants to share any questions that they would have. And in the meantime, Ashwin, you talked about this point wherein the bidders are not allowed to modify their plans, or once they have gotten into it, they are beholden to it, like they cannot withdraw it. So how do you see this? Do you think like this is positive and this will reduce the situations wherein people have kind of put in a bid probably frivolously and then refuse to follow up on it and take it to conclusion?
No doubt. So I think that is well established that not only that is not permitted, and if the bidder were to do that, then there are very severe criminal consequences under the bankruptcy code. It's not just breach of contract and damages. Though that being said, we know for a fact that nobody has been successfully hauled up under that just yet, but those processes are underway. But secondly, I just want to make sure that it does not have an impact on genuine bidders. So for example, if you have a condition that a particular mining license must, consent is required under a mining license, and that consent needs to come, and without which consent the bidder cannot be forced to go ahead and perform on the contract. I think to say that that conditionality is not permitted is a step too far. That mining consent is required under another law. The IBC cannot disturb that other law. So if that mining consent doesn't come within a prescribed period of time, I think the bidder should have the ability to walk away, and the regulatory authority in charge of that mining consent should be incentivized to grant that consent as quickly as possible. Otherwise, I think it puts the bidder in a fairly unviable position, which is what I was trying to avoid.
Right. Okay. And then, you talked about the insolvency of personal guarantors. So where are we on this? Like, do you think this is something that can come up in, let's say, next 6 to 9 months, or do you think we are very far away from that still?
No, Amit, personal insolvency for individuals who have given a guarantee for a corporate debt has already been notified. So that is law as we speak in India. And many of those cases are making their way through the NCLTs as we speak. The challenge is that personal insolvency is quite different from corporate insolvency. And I think a lot of the questions that we faced with corporate insolvency will be revisited with personal insolvency. So let's take a few examples. One, personal insolvency is only available, like I mentioned, in the case where the individual has given a guarantee for a corporate debt. Now, one of the questions in the market is that, look, does it necessarily mean that the principal borrower must also be in insolvency for you to initiate personal insolvency? Or can you initiate personal insolvency even where the principal borrower is not in insolvency? The second question is, personal insolvency is a much more debtor-driven process. The resolution plan is supposed to be proposed by the individual, as opposed to a corporate insolvency process where it's creditor in control, you appoint an insolvency professional and you invite bids. So how successful will that be, where the individual is more empowered than in a corporate insolvency process? So some of these questions will get tested as we move along, which is why I think personal insolvency is will go through the hoops that corporate insolvency went through.
Got it. We have a question from the audience, and basically the question says that, look, for the code of conduct of COC, there is a suggestion that COC should avoid conflict of interest. So will this impact cases where a COC member is also a resolution applicant? And how will that play out? And what is the current market practice around this situation?
I think that's a very good question. And to my mind, it will not impact COC being a resolution applicant. Of course, you have to disclose it, but I don't think it will impact the COC, a creditor being a resolution applicant. I'll tell you why. One, a code of conduct cannot upset that which is set out in the main insolvency law itself. And the main insolvency law makes it very, very clear that any member of the committee of creditor can also be a resolution applicant. That's one. And so to my mind, the code of conduct cannot detract from that. Of course, like I said, but what is happening on the ground in practice today, as you know, there was one case of Bharti Defense where the members of the committee of creditors put forth a resolution plan. And there were many arguments that were raised challenging that resolution plan, and it was ultimately rejected by the bankruptcy court, but not because the committee of creditors was proposing a resolution plan, or prominent or significant majority of the committee of creditors was proposing a resolution plan. That was not the reason. Secondly, if you think about it, if you're going to say that ARCs cannot, if the government is talking about asset reconstruction companies being permitted to participate as resolution applicants, in majority of the cases, if not in all cases, the members of the asset reconstruction companies would be holding debt. So they will be sitting as committee of creditors. So it would be antithetical on the part of the government to take from one hand while trying to give from the other. The third instance in terms of what is happening practically is a little more interesting. So there are a few cases where, obviously I cannot take names, but the argument that is being put forward is that the creditor is not infusing any fresh capital. It is just the case, it's in that sense, it's sort of like a leveraged buyout, that you have bought debt at a discount, you have entered the debt stack, you take a huge haircut, and then the debt is repaid from the revenues of the company itself, and there isn't any fresh infusion of equity capital by the creditor itself. I mean, if you ask me, the insolvency law does provide for some evaluation points for upfront capital and infusion of capital. But I personally am not a big fan of that provision of the law, because once a company has gone into insolvency, then the company needs to be run in the interest of its creditors. And if those creditors don't want to infuse any fresh equity in the company, and so be it. But that sort of theme is playing out in some courts of law, where judges are being told, look, the company is being bought on the cheap and no fresh equity is being infused.
Got it. But I think over there, the response would be, look, COC's wisdom is supreme. So yes, sure, judges can feel like that, but that should not impact the plan, right?
I would think so.
Okay. But actually, it's very good to know that, IBC itself actually envisaged at the time of being formed that there would be situations where a creditor who is part of COC could also potentially be a resolution applicant, and that is explicitly permitted in the IBC itself. That's pretty comforting, right?
That's correct.
Excellent. I think that is all that we have time for. So Ashwin, this has been super helpful. Thank you very much for taking the time out for this. And to all of our participants, thank you very much for joining us today. Please feel free to reach out to us for any questions. And as most of you know, look, we have been like very much involved in several situations in India, and we'll be delighted to share insights with you. Thank you very much.
Thank you.